My name is Mousmouti, and I am an expert for working for the Enforcement Atlas project. So in this short video, I want to talk you through very briefly civil enforcement, what it is, why it is important, and what needs to be done so that we can enforce our claims. Some very basic steps that we all need to know as EU citizens. So let's imagine this scenario. A friend owes you money. They are not giving them back, so you took them to court, and indeed you won the case. You have a judgment in your hands, but now you need to get your money back. How can you do that? And if your friend just goes away from your own country and moves to another EU member state, how does that change the way in which you can recover your claim? This is where civil enforcement comes into play. Civil enforcement is the way in which you can put into effect judicial decisions and other judicial and non-judicial enforceable titles. And it is a fundamental element of the rule of law and the European area of justice. So what it actually refers to are the rules, the procedures, and the actors that play a role and that are involved in all the steps required to enforce judicial and extrajudicial documents in civil cases. So civil enforcement can only take place if there is an enforceable title or document. And what this document does is that it grants the right to enforce a claim and to carry out enforcement proceedings. This is a court judgment or an arbitral award. It can be a notarial deed or an administrative decision. It can be such a document from another member state, or it can be from a non-EU member state if there are specific bilateral conventions that allow it. So if you have an enforceable title or document, you can initiate a civil enforcement process. When you want to recover the money that is owed for you, you can enforce this decision against almost all of the debtor's assets. So a first step is to find out what the debtor has in their possession. So it can be movable assets like cars or other belongings and property. It can be bank accounts and the money that is there. It can be wages or other types of income. It can be immovable property. It can be shares. So enforcement of judicial and extrajudicial documents can take place against different assets in the debtor's possession. There are, of course, exceptions and prohibitions. So welfare benefits, for example, or in some cases unemployment benefits, or a small part of the salary that is necessary for a dignified subsistence, or amounts of money that are due for child support and maintenance cannot be enforced against. This is just to secure that the debtor will be in the position to maintain a dignified standard of living. Not anyone can can initiate and execute an enforcement claim. There are specialized people who do that, and these are called enforcement agents. However, you need to know that they have a different status in different countries. So, for example, in Austria or in Slovenia or in Cyprus, it is the court that has the main role in enforcing claims, and course enforcement agents are directed by a judge. They work for the court. In other countries like Germany or Sweden, enforcement professionals are civil servants, so they might work for the Ministry of Justice, or they might work for a specialized enforcement agency like they do in Sweden. In another number of countries, which is quite big actually, enforcement professionals are independent professionals. They are self-employed, which means that you can choose the enforcement professional you want to work for you, of course within some restrictions that have to do with their jurisdiction and geographical mandate. So once you have your enforceable title or document and you have identified the actor, the enforcement professional who is competent to handle your case, then a next step would be to inform the other party about the initiation of the enforcement proceedings. And this is what is usually done through a service of documents, meaning that we notify to them that this procedure is starting. Then the process of attachment starts, which means that the enforcement agent has to identify the assets in the possession of the debtor and has to create an inventory, for example. This is done in order to be in the position to evaluate them, to assess their value, and assess their value in order to see to what extent the debt can be covered. So once this is done, the next step is to sell these assets, either through an auction or a sale. And there are different ways in which this can be done in different member states, involving electronic auctions or direct sales, or sales through negotiated procedures, or sales through commodities markets. Once this is concluded, and the money is recovered from the sale, then the enforcement agent is the one who will have to transfer this to the debtor. I need to make a note here that these are generic steps of how the civil enforcement process looks like. So if you have a specific case and you are interested in a specific country, you will have to look at the specific rules and procedures that need to take place in that jurisdiction. So please refer to a professional, and also refer to the information that is relevant and applicable for the country you are interested in. So, for example, let's take a look at how you can execute enforcement against movable assets. When you have your enforcement title or document, then the enforcement agent needs to create an inventory of the possessions of the debtor. This is done in order to assess the monetary value of these assets, and this is also performed by the judicial officer, or experts can come into play if the goods can only be valued by experts. Then these goods are sold, and the proceeds of the sale will be recovered and distributed to the claimant. You can also enforce against assets that are in the hands of third parties. So bank accounts, for example. So a creditor's claim can't be satisfied by accessing accounts, or even by seizing salaries or other assets that are in the hands of third parties. So again, for this you need an enforceable title and a court decision. So you need to notify your claim to the bank, and it is the enforcement agent that will do that. The bank then, after it conducts a few checks, it has to freeze or block the bank account. And when everything is processed, they have to transfer the seized amount to the enforcement agent or the creditor directly. What is the costs of enforcement proceedings? Again, this is generic information, but looking at the broader picture, we can see three main types of costs that are associated with civil enforcement. First of all, a fee that is required for starting the case, what we call a filing fee. This is usually dependent on the value of the case. It is paid before the enforcement activity starts, and it will be reimbursed by the debtor at the end, so after the money has been recovered. A second type of fee has to do with the specific enforcement activities that the enforcement agent will have to undertake in order to enforce the claim. These are different for every case, and they might need to do more or less depending on the solvency of the debtor. So enforcement agents cannot charge whatever they want. So these fees are usually fixed by regulation. So it's rules that determine what enforcement professionals can claim. And again, they are usually paid before the enforcement activity, and they will be reimbursed by the debtor. And a third type of fee that might be involved in enforcement cases is a fee related to enforcement performance, which is dependent on the efficiency of the enforcement, and it might be a fixed fee within a specific range or in relation to the value that has been enforced. This fee is usually claimed after the case has been successfully completed. Thank you very much for listening, and in order to find out more about the Enforcement Atlas project and the rules that apply in your specific jurisdiction, please take a look at the site of the Enforcement Atlas project. Thank you very much.